We bring you yet another episode of Dil Se. We bring these episodes to you to have conversations on issues that matter with people that matter. And this time we have a unique conversation, a conversation that is with 3 retired judges of the Supreme Court. And as you know, there's a lot of there are a lot of issues that are impacting the lives of our people. The institution of the judiciary is the only hope for democracy. How well has that institution done over the years? What is the state of that institution are issues that we will be discussing. When judges are sitting in court and part of the judiciary, they're not allowed to go to the public. When they're out of court and they're retired, they say, why didn't you say it when you were a judge? Now, when they were a judge, they couldn't say anything because they were part of the system. They can only say it as citizens of the country when they are retired as judges. So we have 3 distinguished judges who have made a mark in the Supreme Court of India. Justice Patnaik from Odisha, Justice Madan B and Justice Deepak. I want to start with a question, not really with a question, with a thought. What is the Supreme Court of India? There are 34 judges, Chief Justice in 33. How can that ever be the Supreme Court of India? Because judges function in benches. So you don't have one Supreme Court of India. You have several Supreme Courts of India.
See, in the US, they have a Supreme Court of 9 judges. And all the 9 judges sit together and decide. When they hear a matter, after the hearing, the judges sit together and decide whose view is what. And what they do, they break up into the views, say 5 judges are against an issue, 4 judges are in favor. They break up into groups and one of them writes a judgment for the 5 judges or the 4 judges, taking the views of all. This is, I think, the Supreme Court, because Supreme Court of India must have one view. It cannot have, differing views in different benches. Sometimes I have noticed that it all depends what views the judges have of a particular bench, particularly presiding judge. And ultimately, it evens out in the sense that somebody comes and differs from it, right? Another view, then the whole thing is referred to, the issue is referred to.
So there is no continuity. There is no continuity. So if there is no continuity, then the Supreme Court is not really the Supreme Court. There are several Supreme Courts giving different judgments. I mean, in this conversation, we don't ask questions. Anybody can say what they like.
Yeah, well, my view is that it's not as if we have 34 Supreme Courts. You have 34 judges, and when you get a case, when you're dealing with cases, by and large, the judges are in agreement with each other. There may be some instances where, one judge differs from the other, which one can expect, there's nothing wrong with that. And then if that happens, then it goes to, a larger bench. Say if there are 2 judges sitting and they disagree, it goes to a bench of 3 judges. And those 3 judges speak for the court. Now, if you remember, there was a time when Mrs. Indira Gandhi's election was set aside. Justice Krishna Iyer was the single judge, the vacation judge.
Yeah.
He spoke for the court. Right. That time also there were, I don't know, maybe 11 judges or 14 judges, I don't remember. But he spoke for the court as a single judge. Okay. So, yeah, you will have disagreements. I mean, I don't see any difficulty in that. But that cannot be interpreted to mean that there are, the court is a polyvocal court, so to speak, or that there are 34 different.
But the problem, Justice Lokur, is the following, that you have some judges who have a particular way of looking at laws,
Yeah.
another set of judges who have an entirely different way of looking at laws.
Yeah.
And there must be some element of uniformity. Either the court should sit together and say, look, this should be the court's view after discussion, and then implement it. Otherwise, what happens is the high courts, when they are looking at these matters, they don't know which judgment to follow.
Yeah.
And it's not just a problem with one judgment. There are several.
No, on a Monday or on a Friday, there are actually 17 Supreme Courts. I differ with Brother Lokur on this because, and it's like a luck of the draw.
Yeah.
Like which bench you get. You know, we all know some judges are more liberal in granting bail, some are more tough. You see, even with honest opinions, I'm not talking about, it's just a difference of opinion.
Correct.
And when people have different opinions, and when you don't sit en banc, like this sit in most of the world, the Supreme Court sit en banc, we can't, I don't think we can afford to do that also.
Yes, sir.
The problem is we can't afford to, you can't have a Supreme Court sitting because then you'll never get over the cases.
That's true.
So you have to find a solution to that. Whether you have a court of appeal in between or something, that's something later. But right now, I would agree with you that there's not one court. It doesn't speak as one voice. And that is also reflected in the last 7 or maybe 10, 15 years when decisions are being overruled, some of them just in 3 months.
Yes.
A Supreme Court decision, a decision of the court, of the highest court of the land, in my view, should not be disturbed for many, many years, and that too only for very compelling reasons.
Well, let me tell you a problem that we face as lawyers. Nowadays, when clients come to us, the first question they ask is, which judge it is listed before? What does that tell you?
Yeah, because
You know,
every judge has his own predilections.
This is the problem. This is the problem.
Yeah, you're right. I mean, what Justice Deepak Gupta says is correct. That everybody has their own view. And when a client comes to you, he wants to know or she wants to know that, listen, who is the judge?
Exactly.
Because what is the view?
Yes.
Right? So how do you get over that?
But you get over it by, first of all, this Supreme Court of India, look at the kind of jurisdictions it has. It has original jurisdiction.
Yes.
It has jurisdiction of first appeals. Then it is a 136 jurisdiction, right? Then it has all kinds of other jurisdictions.
Advisory jurisdiction.
Advisory jurisdiction. Now, question is, should the Supreme Court of a country have these multifarious jurisdictions?
Mr. Sibal, there is one way which I used to do as Chief Justice of Madhya Pradesh. I found out who are the judges very good in the criminal jurisdiction. Who are the judges who are very good in the civil jurisdiction? Who are the judges who are very good in tax matters? Who are the judges who are very good in constitutional matters? And accordingly formed the benches and ensured that the matters went to those courts. Because ultimately Supreme Court is under Article 141 lays down the law. The law should be correctly law.
That's right.
And if you, in Supreme Court, every judge is assigned criminal cases, whether he knows criminal law or not.
Well, you can't possibly say that no judge knows criminal law.
But I remember once I went to a lecture of Mr. Jetmanani that was taking place in the Amity Law School in Noida. And he told me, Justice Patnaik, why don't you tell your Chief Justice to ensure that criminal matters are listed only before judges who know criminal law? And that's very correct.
That's right.
And I have seen, when I have sat with a judge who is not well off in what you call criminal matters, he'll hear ultimately pass on the matter to me. I know his problem. I have known of judges who don't know very well the constitution matters. He'll hear, pass on to me. But other matters, they are very good. So this is a problem. Some judges are very well off in constitutional matters. Some judges are don't know much of constitutional matters. This should.
All of you have been Chief Justices of High Courts, right? All of you.
Yeah.
And, you must be organizing the courts in the same fashion.
Yeah. Yeah, you see, the problem, I think, in the Supreme Court is this, you have some judges, particularly in bail matters, for
Yes,
example,
yes.
right? You have some judges who are very reluctant to grant bail.
Yes.
There are some judges who are, somewhat more liberal, so to speak.
Right.
Now, that's why the question is asked by your client who's
Yes.
asking for bail.
That's right.
Before whom is
That's why there should be a uniform system view of the Supreme Court.
Right, correct. But there is a uniform view of the Supreme
Which
Court.
is not being followed.
Which is not being followed. So the problem is, not following your own judgments.
That's right. I agree
Right?
with you.
That I think is a bigger problem.
Yeah.
When
I
the
agree.
Supreme Court says that, listen, under these circumstances, you must grant bail. And some judge says, no, I'm not
But
going to grant bail.
this applies to even interpretation of statutes. Why just talk about bail?
Yeah.
One judge interprets that very statute in a different way, just 2 months earlier, and then 2 months later, another judge says, no, I don't agree with this. Now, you see, this brings about a lot of confusion
Yes,
Yeah, it does.
in
It
the
does.
uniformity
It
of the
does.
law.
Yeah,
Say, Mr.
And
Sibal,
something has to be done about
Yeah,
it.
absolutely.
when I was in Madhya Pradesh, I faced a unique problem. There are 3 different benches: Jabalpur principal seat, Indore bench, and Gwalior bench. And the local statutes are same for all. But Indore bench will take one view,
Yeah.
Gwalior bench will take another view.
So this is like Indore and Gwalior in the Supreme Court.
So what I used to do, I used to constitute a bigger bench, right, and ensure that sometimes it has been 5 judges bench, sometimes in 3 judges bench, and all these differences are turned down and said that view taken by the Gwalior bench is not correct. That view taken by the Indore bench is not correct. So one way is that you have to be in the Chief Justice court has to be, our Chief Justice office must be scrutinizing all the time. Which judgments are
Sir, High
different.
Court is fine, but this cannot happen in Supreme Court.
No, I don't see any reason why it can't. We've all been judges in the Chief Justice of High Courts. And High Courts, some of the High Courts have a much larger strength than the Supreme Court.
Yeah.
And the Chief Justice do manage the roster. And especially now with the computerization and taking aid of computers. You see, my view has always been that the Chief Justice is the master of the roster. Somebody has to be given, somebody has to be trusted.
We are going to come to that question shortly.
No, well, we will discuss that. But somebody has to be trusted. Somebody will. But my feeling is that once the roster is framed, and I would agree with Justice Patnaik that the roster should be framed keeping in view the interest and the acumen of the judges in the respective fields. And you frame a roster, but then you stick by the roster. And the roster should play by itself.
Sir.
When it plays by itself, and there's no as little human intervention.
So
as
I have a
possible.
serious issue on that, and we're going to have a conversation on this. You see, master of the roster is fine, but ultimately that's an administrative order, right? Administrative orders must have an element of transparency, right? There is no element of transparency in the context of which matter goes to whom. There are rules of the Supreme Court that are not followed, right? No, but that's a serious issue in the Supreme Court. The rules say that if a matter is before 2 judges and the bench breaks, it goes to the senior most judge. It doesn't happen in Supreme Court. The rule says that if a judge has issued notice on a matter, it must go back to that judge. It doesn't happen in Supreme Court, which means there is an enormous element of discretion. Now, the master of the roster has discretion, but the Supreme Court says discretion must be exercised in a reasonable manner consistent with the rules. Now, should this concept of master of the roster be above the law? Or should it be subject? It can't be.
But Kapil, you've been practicing in the Supreme Court for a long time, right? I remember when I had started over there was no such rule like this.
Yes.
But the convention was there.
Correct.
So if the convention was being followed, now that convention has been made into a rule.
That's right.
So follow it.
No, my view is very simple.
Yeah.
That the master of the roster is the master. But once he frames the roster, then he becomes subservient to the roster.
But sir, if you say all criminal courts, the problem is you say all courts will have criminal jurisdiction. Then what's the roster?
That is a bad framing of the roster. See, the thing is, if you frame the roster properly, Brother Patnaik must have done it, and he must have done it in Hyderabad and Madhya Pradesh with a number of judges. We've done it, I've done it both in a very small high court and a larger high court like Chhattisgarh, where human intervention is the minimum. I can tell you in Chhattisgarh, my registrar judicial told me that now for 15-20 days I don't have to come to you for getting orders on a particular case, because the roster, it says if it can't be listed before DB1, it will go to DB2. If it can't be go to DB2, you see, and it's not by name of judge, it's by the division bench or single bench number. We here, unfortunately, that has not been the practice.
Yeah, but if I may just add a problem in that. Supposing the criminal cases are being dealt with by a judge who is conservative, does not want to grant bail, and the master of the roster says, all right, you're going to deal with all criminal cases. Guys who are asking for bail have had it, yeah?
No, that's why I say...
This is the problem.
This is why I say ultimately it goes to one question. As he has also said and I have said, the benches who are well acquainted with the particular matter, criminal matter, civil matter, constitutional matter, they will sit constantly, and the Chief Justice should, when a bail matter comes, send it to the criminal bench. And Chief Justice, while deciding whom to grant bail or not, has to decide who is balanced, who is not conservative, who is not who is balanced.
That's the problem.
That the Chief Justice decide.
You're
and
right.
give all. When I was in Madhya Pradesh, there was one judge. I found no complaints against his bail orders. Very balanced, very balanced. I ensured and requested him, you please sit in the bail matters. And he did very well. And if other matters sit, so much of complaints. Somebody is very liberal, somebody is very conservative. So you have to select the right judge and put it
The
down.
problem is far more serious. I have been now practicing for 50 years. Now what has happened, I've not seen this before. What is happening is now the process of appointment of judges is such, and I'm sorry to say this, that there is an element of a compromise, right? Because government wants certain people and the judiciary wants certain people, and you can't proceed further unless both of them agree, right? So either you stall the whole employment process or you compromise. Now what happens is there are key Chief Justices who are placed in different high courts, right? Depending on the nature of the compromise. They become masters of the roster. There, the most sensitive cases are to be assigned by them to judges. And I have seen in the last 10, 12 years that that's very troublesome. And so this emanates from the process of appointment of judges, right? Now, how do we settle that system? How do we make it more effective and more ultimately, the judiciary must be independent. Without an independent judiciary, democracy will be, in great danger, and it is. How do we do that? And why are we not applying our mind to that?
Just a minute. Have you seen the changes that have taken place in the UK?
Yes.
Now they have changed the entire system of
Right.
appointments. They have appointed a judicial commission, right?
Yeah.
Now, the first motto they say, Lord Chancellor has to ensure that any appointment, any transfer takes place, the primary thing is rule of law and independence of judiciary. Statutorily laid down. And there is no constitution, no written constitution there. In fact, I'm writing that books, it's not come out. So I have compared the UK institutions. They've done a wonderful job. Somewhat at that kind, but the problem is it has to be done at the legislature level, parliament level. Who will do it? Parliament must get interested.
No. Parliament is now saying that, look, there's no basic structures. Where's the
Yes, yes.
We're going the other way.
Parliament does it.
Yes.
So ultimately,
So there is no hope. That's what it comes to. There is no hope unless you settle the system and set it right. And Parliament is not willing to do it. Courts are continuing in this fashion. Where do we go from here?
You see, it's like this. First of all, I must tell you that I am not in favor of the transfer policy. All right. you say that you're transferring judges in the for the better administration of justice. I don't know what that means, as if the administration of justice is suffering.
Like Justice Muralidhar,
Yeah, why was he transferred?
Yeah.
There's so many of them. I mean,
Akil Qureshi.
Akil Qureshi. There are many of them, and that is one. The second thing is the appointment of a chief justice from outside the parent high court.
Yes.
Now, the reason why that happened was historical. I mean, there's something that happened which led to this decision being taken. But those circumstances don't exist today.
Yes.
They've not existed for the last 10 years or 15 years.
Right.
So the policy of having an outside chief justice, I think, should be scrapped. That's the first thing. Why? Because like Justice Patnaik says, the chief justice, whoever he is from his own high court, he knows
Yes.
all the judges.
Yes.
So he knows who's good in constitutional law, he knows who's good in criminal law, who's good in civil law. Don't have somebody from outside come in who doesn't know anything about that high court. So I think the first thing that they should do is they should just scrap this idea of having an outside chief justice. Once that is taken care of, scrap the idea of having transferring judges from here to there. Why do you want to do it? I mean, if a guy is doing something wrong in his own high court, what is the guarantee that he will not do something wrong in some other high court?
I agree.
Right? And if you have information that he's doing something wrong in this particular high court, take action.
Yes.
We've had an instance where something wrong was being done by a judge of the Delhi High Court, and the Chief Justice told him that I think it's time you quit, and he did quit.
Yes. Yes.
No, I agree with Justice Madan Lokur on that this transfer policy as well as the appointment of chief justices from outside is no longer valid or good. It doesn't work in this country. It's in fact being used to circumvent the independence of the judiciary.
100%. Yes.
So, I also find it another reason, coming from a smaller high court like Himachal, that smaller high courts neither find representation in the Supreme Court, nor do they have there are many states in this country which do not have a Chief Justice represented anywhere. Yes. Otherwise, if they had their own court and their own Chief Justice, I think Justice Wazir was Chief Justice of J&K for about 17 years.
Yes.
But then that is the way it is. It should be.
That's right.
And most of all, I feel that when you feel that a chap is not working properly or is dishonest or for whatever reason you want to transfer him from one, why should he be put into another court? And normally you'll choose a small court like Sikkim or Himachal or somewhere, as if those states don't matter.
Exactly, I agree.
And in fact, he may be number 10 or 20 in his own high court, and in a smaller state he just becomes a part of the collegium, or he's J1 or J2, exercising all those powers. I think it just backfires. It doesn't work at all. I have, may I take 2 minutes on this appointments? I have 2-3 issues. I mean, what Arun Jaitley used to say. One, the retirement age should be the same for judges of the High Court and the Supreme Court. This unholy hold which the judges of the Supreme Court, especially the judges of the Collegium, have on senior judges of various high courts, and this pain in the neck which many of us get in the High Court looking up at the Supreme Court, this way has to come to an end. That is one. So you make the age equal, and for 3 years you keep filling vacancy, your vacancy position will also improve hell of a lot. It will really, you'll fill up a lot of the vacancies. And most of all, I think, most importantly, there should be no post-retirement jobs for judges. You give them good pensions, whatever, and we all join. When we join judgeship, we know this is what we're going to earn, and probably we all earn much more than what we thought when we joined. The salaries, the perks have increased quite a bit. It's not that.
But there are 2 elements in this transfer policy that I want to just seek your views on. What the transfer policy does is you pick up a junior judge in a court, make him Chief Justice, right? With the intent of having him come to Supreme Court earlier, right? Now that's very dangerous.
But that has been happening for a long time.
I know that. But now what is happening is like the army, you decide who your Chief Justice is going to be 10 years ahead. That's what's happening in the judiciary. People who have worked with certain people, with certain judges in the high courts that they're in, they want to bring them to Supreme Court. And therefore, that's one aspect. The second aspect it has destroyed the independence of the high courts. Because the collegium system makes the judge in the high court look up to judges of the Supreme Court, right? And then make sure that they please them in order to come to Supreme Court. And that sort of, in fact, impacts their independence while functioning as judges in the High Court. This is what I have felt. I may be dead wrong, but I wanted your views on it.
Yeah, about the observation that the judges of the High Court look up to the Supreme Court or look up to the collegium in the Supreme Court.
Right.
Yeah, that is correct. I'm not doubting that. But how do you stop it? One way of stopping it is that the judges in the collegium, every weekend everybody goes to some high court or the other.
That's
right. There was a time, I remember, when the judges used to go to the Judicial Academy, okay, because they would try and, meet the judges, discuss issues with them in the Judicial Academy, not go to the high courts. But now, judges of the Supreme Court have virtually stopped going to the Judicial Academy. Once or twice somebody goes, but they go to the high courts. And when they go to the high courts, they're treated like, like kings, so to speak.
Demigods.
Yeah, like demigods. Just for this reason.
Yeah.
So I think there has to be, when you talk about self-restraint, judicial restraint and this, that and the other, I think this is one of the areas that one has to look at, definitely.
But it's a systemic problem.
It's a root
It's
cause.
a systemic problem, yes.
Mr. Sibal, root cause is that collegium judgment. Once you concentrated powers with the 5 judges of the Supreme Court, senior most judges of the Supreme Court, then every Chief Justice thinks that if I have to go to Supreme Court, I have to please them. Right. And shall I tell you truly what happens? Chief Justice has different programs on the Madhya Pradesh High Court or Chhattisgarh High Court or Guwahati High Court or say, wherever it is. Programs are organized, and when it comes to invitation, he ensures that a judge from the collegium comes there.
Yes.
I've seen this from Guwahati days, 94 Guwahati days. So this is the problem with that collegium judgment. Prior to that, I have known of Chief Justices not bothered who came from Supreme Court and not. They did their own job. One is your GP Singh, Justice GP Singh. The other, I found many judges in the Chief Justice of Orissa, S.K. Ray. They were all very independent. The judges of the Supreme Court came to Bhubaneswar, they come to Cuttack or not, they go to Puri, have a darshan, go back. They are not bothered. Right. This is what it is. So the root cause is that collegium judgment.
No, I agree.
And one solution, as he rightly says, you make them equal.
The problem is there's a Brahminical culture there also, I believe. I'm not in the court. I don't know about the judges there. But there's a Brahminical culture. Why? Because the judges of the High Court look only to those 5.
Yes.
Yeah.
They don't look at the others.
Yeah.
Yes.
Right? Yeah. And I think those 5 also believe, because they know the future is there.
Yes.
They also know that, and even the registry in that context is more concerned about the 5 than the rest.
Yeah.
I mean,
No, that's a hard fact.
Mr.
Because
Sibal,
they knew that I will never reach the collegium, so this is different treatment meted out.
See, this is not right.
Yes,
You know,
Mr.
and the
Sibal.
court has to correct that.
Yeah.
Shall I tell you one thing? When I entered the collegium, I found more judges coming and meeting me from the high courts. So why this happened? Tell me.
No, we all know why it happened. But let me go on to another issue, I think, which also relates to the master of the roster, if I may go back to it. Now, why is it that matters of great importance take 5 years to be heard? What's the relevance of hearing a matter after 5 years? There's no point.
You're right, 100% right.
So why, when we talk about कि वकील तारीख पे तारीख लेते हैं, तो तारीख पे तारीख तो जज भी लेते हैं.
Yeah.
This is तारीख पे तारीख.
No, when there were
No
issues
way.
like the Kashmir case,
Yes.
when habeas corpus petitions are not taken up for years on end.
Exactly.
See, I've written about this somewhere else also. When Mr. Kuldeep Nayyar was arrested and the bench of
Yes.
Justice Rangarajan and Justice R.N. Agarwal heard in the Delhi High Court.
Yes.
And when the government saw the way the wind was blowing in the court, they withdrew the order of detention.
That's right.
And moved an application that now you dispose it of as infructuous. The court said no. He has a right to know why he was even detained for 1 minute. And nowadays, hundreds of
That
habeas
was the
corpus.
culture. When I filed these petitions in the Supreme Court, all of this went to a particular judge. Adjournment after adjournment after adjournment. What's the point of having a habeas corpus petition? What's the point of not hearing the demonetization issue,
Electoral bonds.
electoral bonds issue?
Yes, yes, you are right. Habeas corpus petition, matters of personal liberty, right? They must have priority.
But the culture of liberty doesn't exist, unfortunately. I'm sorry to say. Where is that culture of liberty? I have great to see. We are all part of that institution. We love it. And our passion is to make sure that it's independent. Why are we having this conversation? Because we are worried. And that culture of liberty has diminished to such an extent that clients feel क्या फायदा है जाने का? इससे better तो it is better maybe trial court में ही शायद मिल जाए.
Yes, yes.
This is the view, unfortunately. So and there the master roster is in complete control, as you mentioned.
Yeah.
Right. So why are the cases listed after 5 years? No explanation.
Yeah, that's a very serious problem.
It's a serious problem.
So you've had demonetization, you've had Kashmir, you're now going through this electoral bonds. You know, yeah. Why did it take so
No,
long?
Chief Justice, as the Master of Law, must ensure that these important constitutional issues and matters of personal liberty must give it priority. There is no doubt about it.
That's right.
I don't know why the Chief Justice doesn't do it.
See, the Indian Supreme Court is not only an adjudicator of disputes, but it is also the protector of the civil rights. We are probably the only country in the world which has something like Article 32.
Yes, Article 32.
It is the most powerful court in the world, but it is showing itself to be powerless. That's the tragedy of the Supreme Court.
The protection of human rights is very, very essential, and that I feel there has been something more could have definitely happened in the last year.
I can say this because of my own experience. When a matter of great public importance or public interest used to happen, Justice Bhagwati used to suo motu take action. He didn't wait for a petition.
Yeah.
Yes, yes.
It's a matter of great public importance. There are so many things happening in this country.
Yes,
somebody is slapped in a classroom.
Yes, yes, correct.
Right? You know, somebody is made to say a certain thing, and somebody makes a hate speech. We go to court, we file petition after petition, nothing is done. Why should I have to file a petition? The Supreme Court should suo motu take notice.
You are right. You are right, 100% right. Because I remember, I read morning newspaper every day. One morning I read, one girl has been gang raped. Dalit girl. In some place in Madhya Pradesh. So I took that piece from the newspaper, entailed a suo motu public interview. And the moment it happened, the police people came and arrested her. Arrested all four of them. Four of them had gang raped.
Sends a great message.
Right. Somebody had written from the prison in a postcard that our diet is like this, very bad diet. I entered that appeal, directed all the district judges to inspect the jail and report on the diet, and it was found that was correct. That to be rectified.
So why doesn't the Supreme Court use its suo motu power?
Yes, yes, correct.
You see, I would just like to add or continue what he is saying. You know, one is the Supreme Court not exercising suo motu power. It should.
High Court also.
What about the High Courts?
Yes,
High
I
Courts
agree.
You know,
I agree.
I mean, everything is not of national importance, but it is of state
bulldozing houses.
importance. Yeah, correct. Absolutely. Why does somebody have to go to the court?
Exactly.
You know, the High Court should say that, listen, what's going on? You better tell us. You know, but the High Courts are not doing it.
Yes.
One of the reasons could be that they're looking up to the Supreme Court.
And the Supreme Court is not doing it.
Yes, yes.
We had Justice P.D. Desai as our Chief Justice for 5 years.
Wonderful.
Probably one of the most wonderful judges this country
Yes,
has
yes,
known.
yes.
And in those 5 years, the number of public interest litigations he entertained, suo motu, it transformed Himachal Pradesh
Yes.
in many ways. and everything was done for the public good.
Yeah, yeah.
It was never done for any political reasons or anything. Nowadays, Mr. Sibal, the problem is, even a person like me who's more like, in favor of PIL becomes very, very hesitant to it, because large number of the PILs are motivated either for business reasons or for political reasons.
Absolutely.
And you get very, you're a little wary and chary of whether to entertain such a petition or not. That's the counter. Though I still feel judges, especially when nobody's come to court, it's better for the court itself, because then no allegation can be raised that it's for a reason.
That's correct. And courts are witnessing these incidents day in and day out.
Yeah.
And they are waiting for somebody to file a petition. Why?
See, in a country like
It's not
India,
necessary.
where more
Not
than
necessarily Chief Justice can take so much.
Yes.
And that is the judgment of Supreme Court also.
Right.
But only Chief Justice, nobody else.
but other judges
Others can bring it to notice.
You can tell the Chief Justice.
But even that is not done.
Even that is not done. And the other thing that I'm seeing in court again is that nowadays brothers judges don't speak. Who are sitting, puny judges don't speak. Why?
Really? In the court?
Yes.
Yeah.
Why? They don't differ. Why? And I've seen them wanting to differ. And the senior judge sort of does something like this. That's it. Now, that's not right.
That's not right.
absolutely wrong.
No? We shared the bench for 17 months.
Yes.
Yeah.
Or a little longer, I think, maybe.
Yeah.
From February 17 till he retired in December
Yeah.
19,
18.
So we shared the bench for almost 2 years.
Yes, I know that. I was appearing before.
But then we differed. I did differ with him.
Yes. No. What is happening now is you can see it on the screen. So when the gesture is made, it's those people in the court who are telling me, why did this happen? Did you see what happened? That's most unfortunate.
But on a lighter side, I can say that once I wanted to differ, but when the Chief Justice issued notice,
yes, then of course.
That's
the other thing. Now, if the other judge wants, the norm was, the practice was, if one judge wants to issue notice, then the senior judge agrees.
Yeah.
But that's also not.
No,
being
here I didn't want a notice to be issued, but when the senior judge, then you don't. Then you don't.
Of
That's
course.
it.
So that kind of camaraderie also.
That I don't know. I hope because
I
we don't
think-
have the benefit of watching like you.
No, one thing may be happening. Most of the judges who are coming from the High Court, they are not aware of all those earlier approaches of the Supreme Court, judges differing and all that. Let me tell you, let me share with you an order that I read. When Justice Beg was the Chief Justice, somebody published in the newspapers, this is during emergency, that registrar of the Supreme Court of India issued a letter to different high courts saying, high courts are not functioning this way, that, and all that. And he said that during emergency, high courts have been functioning much better than the Supreme Court. Right. It's doing much better than the Supreme Court now. So Justice Beg issued a notice of contempt. Fortunately, Justice Krishnayar was sitting there with him. And he said, where is the contempt? Where is the contempt? No. Then he wrote it and said there is no contempt, he dropped it. So you see this, how a puny judge also differs from the Chief Justice. Absolutely. And these are good messages that goes to the High Court also.
Right.
Once we look up to Supreme Court, when I become a judge, I found Justice Venkatchalia was there, Justice V.S. Marwa was there, very good judgments coming. And we used to get inspired by those judgments. Justice Sawant was there.
Yes.
Very good judges. And we used to get absolutely inspired by them. And we developed ourselves in that mold. And we come to Supreme Court perform that way. But today's judges, if they send this kind of message, the Supreme Court gets a message. These judges that will come, they will develop in a different mold. They are also human beings.
Yeah, you're right.
They are not saints. Right.
So actually what we have now done today is just started a conversation that impacts institutions, impact the lives of millions of this country. And the only institution that can actually protect those people is the judiciary. And therefore, we are having the first of these conversations. We will request you, sir, to come again.
Sure.
But there are so many issues to be discussed.
Sure, sure.
And,
Let me respond to you by saying this. Once we are retired, nobody is bothered about us, right? they only...
Sir, but you are bothered about the institution.
We are bothered.
Yeah.
But the first person who has called us here for a discussion is you. I must thank you for that.
No, thank you for coming.
thank you.
And we will continue with this conversation.
Definitely.
Hopefully once a month or twice, once in 2 months. Thank you very much.
Thank you.